seated. Morning.
Good morning, Your Honor. Sean Breacher from Young Conaway on behalf of the debtors. Your Honor, we generally start these cases with a quick status update, and I'll just give you a quick one. On the first day hearing, you'll recall Mr. Brady described the three phases we anticipated in this case. Phase one being stabilizing proper management and oversight of the business, ensuring animal safety and necessary operational controls in connection with the Chapter 11, getting our arms around the financial operations of the business, digging into the company books and records, complying with reporting requirements called for by the rules, and determining the best path forward through this process from an operational standpoint. Your Honor, we feel like we are getting close to closing out most of phase one. Sadly, it took much longer and was much more costly than anyone hoped. I think that was caused largely by Mr. Albor's willful stay violations, and we still do have some gaps. We'll hear more about those later today. Unfortunately, we've uncovered a number of operational challenges resulting from some of prior management's decisions, which the run team has been tackling. Phase two of the case was estate value maximization. That process is now underway, and we expect this to kick into full steam as the phase one process starts to taper off. The advisors, Greenhill and Keene Summit, have kicked off the marketing process. We hope that the procedural orders related to future sales will help us move forward quickly to preserve and generate as much value as possible. We've received substantial interest from various parties as to a number of assets, and we're optimistic that the process will be successful. And then we talked about phase three. We now do have most of the books and records preserved. We're learning more and more each day about how these companies were run, and we will be poised for a full investigation and accounting of the historical issues related to these debtors. So I think in sum, we are moving forward. This has been a challenging case so far. We are hopeful that we are getting to a place where this becomes run more like a normal Chapter 11 case in short order. So with that, unless Your Honor has any questions, I'll just kick into the agenda. Let Mr. Koshinash step up.
Thank you. I do not have any questions.
Thank you.
Good morning, Your Honor.
Good morning.
Jared Koshinash from Young Conaway, Starry and Taylor on behalf of the debtors. I'll be handling the miscellaneous asset sale procedures and the bidding procedures motions. But first, a little housekeeping matter. We did submit a declaration from our investment banker, Mr. Jakob Malechko, at docket number 364. Mr. Malechko is appearing virtually today, and we thank Your Honor for allowing that. So with that, we would respectfully move into evidence the declaration of Mr. Malechko.
Is there any objection? I hear none. It's admitted. Does anyone wish to cross-examine or is going to wish to cross-examine Mr. Malechko? I hear no one.
Thank you, Your Honor. Mr. Malechko has actually an immovable conflict towards the end of the hour, so unless Your Honor has any questions for him, we would respectfully request that he be permitted to leave the virtual hearing when appropriate.
I don't think I have questions for him. I have some questions. We'll get to them.
Okay, Your Honor. Sounds good. Thank you very much. So starting with the miscellaneous asset sale procedures motion, I think before we get into it, it's important to sort of take a step back and set some context for when we were preparing these motions about a month ago. First, the debtor's assets, as you know, comprise a very diverse set of assets, both in terms of their geography and the types of assets. They range from parks, equipment, and obviously to animals. Moreover, some properties are going to be sold as going concern sales, while others may just be sold for the real estate. And obviously, in addition to those levels of complexity, you have all the issues that Mr. Breacher was just referencing a moment ago, where we have been struggling, but no longer struggling, but to obtain control of the books and records. So when we started out, this was sort of a black box, and as we've progressed through these cases, it has become less and less of a black box. But when we filed we did need to file the motions, and we needed to do so in order to be ready to basically hit the ground running when the time came, and that time is now. In those levels of complexity, to address those, we created a framework that we thought provided flexibility while also building in what we believe to be appropriate notice to parties in interest. But now that we have steadied the ship, we are hopeful that this will, as Mr. Reacher also alluded to, become more of a normal, standard sale process where we can hopefully group as many assets together and we are not running multiple parallel sale processes at the same time. I think we are trying our best to be efficient as possible while also progressing in a way that maximizes the value of the debtor's complex asset structure. So with that sort of high-level background, I guess I would move into the miscellaneous asset sale procedure motion, which is agenda item number 8 and docket number 298. I don't think I need to add much to what I've already said and what's set forth in the motion. These miscellaneous asset sales are, again, designed to provide efficiency and flexibility to the debtors in monetizing their various assets. And with respect to this particular motion, we have 3 categories of assets: the real property, the personal property, and the animals, all with their varying thresholds and notice periods. But with that, I guess I would open it up to your honor to address any questions that you have.
Well, the big questions I do have, I guess, on this sale motion is with respect to the animals, which are included, and who is getting notice with respect to the sale of a particular animal or group of animals. Because I did not see in this motion any notice to any regulatory body that's responsible for animal welfare.
Understood. And I think we would give them notice, but I think we can make that more explicit in the order by adding into the notice parties all applicable regulators, if that would solve your honor's concern.
I think it's a must.
Yeah.
It's not discretionary. And they need to get notice of any sale of any animal. And I would like in here who that is. I would like the applicable regulatory entities specified. The debtors should know who those entities are, the regulators or whoever they are, and they need to be notified on every sale of any animal. Or if something's, I can't imagine, you're abandoning any animal or whatever the situation might be. But I thought that was a notable hole in these procedures. I think the miscellaneous asset sale notice, to the extent that it deals with an animal, needs to also include how that animal is being transported, how it's being protected, etc. There needs to be more. This is a unique, in this aspect, and maybe only this aspect, this debtor is unique, and the multiple sales, or we're selling it in piece parts, or they're not going concern, none of that is atypical. I think the only atypical part of this sale motion is that we're dealing with animals. And so that's going to be my question on every sale or other disposition of any animals is how are they being cared for, how are they being transported, who's overseeing it, do the regulators have the appropriate notice? That's what I'm going to be looking for. So that needs to be specifically put in here.
Understood, and we will certainly do that. By no means were the debtors attempting to flout any of their responsibilities to regulators. We are very keen and acutely aware of all the regulations, and we understood if there is any disposition of animals, we certainly were intending to follow and provide notice to all the regulators. But I agree that we can include this more explicitly in the order and notice.
Yes.
And I should note, you mentioned abandoning. We do not. This is not like the other de minimis asset sales. I did a Control F for abandon before I got here, and there is no mention of abandonment. So this procedure will not be dealing with abandonment. But we appreciate Your Honor's comments, and we will incorporate those.
Okay. That's the only issue that I had with the de minimis sale motion. So if you revise that form of order, submit it under certification after it's been circulated, I anticipate signing it.
Understood, Your Honor. And for the notice, I guess we will put in a bracket to be updated as applicable if and when an animal is sold.
Say that again?
Just for purposes of submitting the order under COC, in the notice, we will put a bracket in for basically who will be in charge of the transportation to be updated at the applicable time when an animal is sold, to make it clear when the order goes out that if and when we sell an animal, that bracket will be updated with all the necessary information.
Thank you.
Thank you, Your Honor. So moving on to the bidding procedures motion, we did receive several comments from several parties, and first I'd like to thank the Office of the United States Trustee. Ms. Leamy is here, who is filling in for Ms. McCollum, who is filling in for Mr. Hackman. We thank all of them for participating in their responses. I believe they were very additive in this regard. But after we did submit a COC resolving the various comments from the parties, but when we heard from Your Honor's chambers that there was questions, alarm bells went off at the offices of Young Conway, and we did a more thorough scrub of the order. We didn't want to mark it too much further after we submitted a COC, but we did catch some more issues that may be helpful to Your Honor. And we did circulate an incremental red line to the various parties, including the United States Trustee, the Official Committee of Unsecured Creditors, and all the other respondents who did provide comments to the form of order. I do have an incremental red line. It is just 7 pages, mostly clarifying changes.
Thank you.
Thank you. I can quickly walk through these. I don't think they're controversial, and as I said, I believe all the parties who received this, I circulated a few hours ago. Most, if not all, have responded with saying they do not object. But just to quickly walk through the incremental red line, this first one on page 8, this just clarifies that the objection will be filed following the filing of a stalking horse notice rather than just simply thereafter, which was a little unclear in the order. On paragraph 15, when the debtors are serving the bidding procedures, we have added to the extent not already served. I believe that came about because the bidding procedures were originally attached to the motion, and so now we have included the bidding procedures as a exhibit to the order. So I think paragraph 15 would have been a little duplicative in terms of serving. So that is the reason you see that to the extent not already served. The next one on paragraph 21, electronical is, I don't think, a word, although spell check did not catch that. This, I would say, is the more substantive change, but again, it is not prejudicial because this is with respect to the service of a cure notice. We had originally put in service on bid procedure notice parties, which actually, as a defined term, included the creditor matrix. And I don't think we ever serve cure notices on the entire creditor matrix. So here we've changed that to the non-debtor contract counterparties and all those entitled to notice pursuant to Local Rule 2002. The next one, again, is a clarifying change, just making clear that the objection we are speaking about with respect to the designated contract is with respect to the assumption and assignment of the designated contract. Paragraph 26, again, electronical. And then in the first sentence, rather than say listed above, we were more specific and put in paragraph 25, which sets out the actual specific items that we are referencing there. Paragraph 17, this discusses objections to the proposed form of adequate assurance. This was, I think, a holdover that was not updated when we received comments from the landlord. It basically says that the original order had said that the objection will be heard at the sale hearing or supplemental designated contract hearing, but we have since changed that in connection with some comments that we received, so we just simply put in accordance with this bidding procedures order. And then, again, the last one is paragraph 32, and that is just, again, a clarifying change that an objection must be filed no later than 3 business days, but it can be filed earlier than 3 business days. So that's the incremental changes from what was filed as a COC at docket number 369. And again, I won't say, I don't think I need to say much more than my introductory remarks with respect to the bidding procedures. We designed them in a way that we hoped balanced the need for flexibility in these cases while also providing adequate notice to all parties in interest. So with that, again, I will open it up to your honor for your questions.
Okay. I do have questions regarding the contract assumption and assignment procedures. And I'm not sure, quite frankly, if the motion differs from the order. But I flagged some things in the motion, and particularly on page 31.
This is 31 of the motion?
Of the motion.
Okay.
I just want to make sure I understand what's happening. Because of the way that these notices are going out, are people going to be, counter-contract parties, going to be receiving more than one notice with respect to their contracts? Are they going to have to keep looking for something else in the mail that says you may be impacting their contract? Because that's how it struck me as I was reading this, and I could be wrong.
Apologies, I'm just reading what you're referencing to make sure I understand the concern.
Well, first it starts, we're going to post on the website. Well, that's not notice to anybody, posting on a website, okay? So do I have to look on the website? Is it going to be changing? How many notices am I going to get? It just seemed to be a little unclear to me of all the places that a counter-contract party is going to be expected to look to protect their rights.
Sir, I believe the case website and the various provisions related thereto were included as just a backup means in case parties wanted to look, or more of a belt and suspenders sort of approach. With respect to whether they will be receiving multiple notices, I I don't believe that would be the case, but if it is unclear, that is something that we can revise to make clear that I think the way it was structured or supposed to be structured was the contract counterparties will be getting a notice, as they typically do with respect to the cures, and if there's any amendments to that, we would file a supplemental contract notice. But I believe I understand your Honor's concern with respect to how this is structured or at least phrased. We can clean this up a bit to make it clear that they will only be receiving one notice. I think this was more, like I said, a belt and suspenders, not meant to confuse anyone, but I understand your Honor's concern.
Okay. The footnote on this page, for the avoidance of doubt, the failure by the debtors to list a contract on the designated contract list shall not be deemed an admission that it's not executory and not subject to assumption and assignment, and the proposed cure cost for any such contract shall be deemed zero. I don't get that. If you didn't put it on the designated contract list, there's nothing to deem zero. You got to send a notice to somebody and you got to send them a cure amount. I'm not going to deem somebody zero by the absence of the contract on the designated contract list.
Understood, Your Honor.
And I don't know that I found that in the order, but since it's in the motion, I'm raising it. If it's in the order or if it's in any of these notices, it needs to come out.
Understood. I don't believe it is, but we will scrub the order and notices to make sure it comes out.
Okay. Paragraph 40. A counterparty to a designated contract listed on the notice of assumption and assignment may file an objection only if such objection is to the proposed assumption and assignment of the applicable designated contract or the proposed cure cost. What does that mean? They can't file an objection on some other basis? Am I limiting objections that people can file? Again, I'm not sure I saw this in the order, but it's here in the motion. And it's, to me, an unusual provision.
I think that was referencing specifically with respect to their, if they receive, I don't think it's precluding them from raising an objection with respect to the sale or otherwise, but if you are listed on the notice as a contract counterparty, if you are objecting to the notice itself, that would be limited to the assumption and assignment of such contract. But I don't think that is precluding.
I'm not going to make someone file 3 different objections. They can file one objection to anything they have. If they want to file more than one objection and separate out their notice and cure amount from their sale objection, they can. But I'm not precluding people from filing one objection to whatever it is they think they have a right to object to. So if that's in the order and I missed it, that's got to come out.
Okay. Understood. I don't think it is. I will double check. I'm not sure if it is. I don't think it is, but we will double check to make sure.
Yeah, paragraph 41 suggests the same thing. So it's, if a counterparty to a designated contract, if they file a designated contract objection that is consistent with the requirements set forth above, then something happens. I'm not getting that granular, okay? They file an objection, they file an objection. We deal with it. Doesn't have to be consistent with some preconceived notion that the debtor has about how that objection should look. Again, I think these are unusual provisions and unnecessary. paragraph, I'm looking at the order now,
The red line with the COs
the red line.
Okay.
Okay, I'm not sure I fully appreciate the sliding scale you have here on all the different days. But somewhere I thought the sale objection deadline was 30 days after service, and here it's 15 to 60 days. So when does the 15 days kick in versus the 30 days?
I believe you are referencing paragraph
32 says objections to any sale transaction must be filed no later than the date that is 30 days from the bid procedure's trigger date.
Yes.
And then in your timeline back in paragraph 2, the bid procedure's trigger date is day 0, and sale objection deadline is 15 to 60 days. So how does that comport with paragraph 32?
Yes, this was something that we also saw and thought that we would discuss. But I think with paragraph 32, this is a no later than date. I think nothing in this chart that you're referencing was meant to deviate from any local rules or notice requirements. So I think the day 15 sale objection deadline is we would go out with, in some circumstances, the regular 21 days notice with an objection deadline of 15 days out. But we are in no way attempting to deviate from any of the rules, and we can set the objection deadline for day 30 in the chart to make it clearer and comport with paragraph 32. And with respect to the outside date of day 60, that I think just reflects the potential for the debtors to set a later date if necessary, which would be beneficial to creditors and provide more notice. But if there are any things that we could clarify with respect to this chart.
I appreciate the attempt to try to build in flexibility, but I think you've actually confused many things in doing that, and I'm not sure it was necessary. I can tell you right now that if anybody misses a date, there's going to be a lot of leeway given to people, because I think this is confusing. If 30 days is an outside date and you make something 15 and somebody thought they had 30 days because they read this, they're going to get 30 days. So I think it's confusing. And I don't know how sitting up here on the bench to make your order not confusing, okay, with respect to these sliding scale days. But I'm going to give people leeway that miss a deadline because of these sliding scales and the inconsistencies. So that's all I'm saying.
And as my colleague, Mr. Greacher, whispered into my ear, and I agree with, when these notices go out, we will be clear on the specific days. I think that the point of this order was to provide a sense of the potential timeline in connection with these sales. But when we do file a trigger notice, it will say your objection deadline is day X.
Okay, and what deadline am I approving with respect to that if it's not in here and it's not clear?
I think you would be approving, if Your Honor agrees, with paragraph 32. The objection deadline set forth. It shall be no later than 30 days, unless it.
Well, I'm more concerned with it's no earlier than. No later than doesn't bother me at all. It's the no earlier than. If you said something for 7 days, that's no later than 30, but I might have a problem with 7 days. So it's really the no earlier than that I care about, and that that matters for purposes of appropriate notice, not that outside date. 30 days is fine for notice of a sale, I think, under our rules, but 7 days would not be. So I find this order confusing on the dates.
Understood. I think in paragraph 32, would it be acceptable to change it from no later than to no earlier than?
I think it should be no earlier than. I think the no later than doesn't matter.
Understood. So we will change paragraph 32 to no earlier than?
No earlier than whatever the rules provide.
Correct.
Whatever date that is, which I don't know off the top.
And then we will change the chart from day 15 to day 30.
However your chart works, I will confess to finding the chart confusing.
Understood. And like I said, this was unique circumstances, and I don't think you'll ever see this chart again, God willing.
You should put that in the order somewhere.
But yes, like I said, this chart was meant to set up basically parameters for how the sale process is going to play out, to give parties at least some sort of idea as to when they would expect the various time, how the process would play out and the various dates. But when we file the applicable notices, we will do so in a way that comports with the date ranges set forth in this chart, but they will be exact dates to make clear.
Okay.
So it will not be we are having an auction sometime in the future between days 30 and 35 and 80. It will be we are having an auction on day whatever day 40 is. That will be the day that is in the notice. I think the attempt was for Your Honor to approve, as long as the dates that we set forth in whatever notice that we file, as long as the dates fall into these date ranges, that is what we are asking Your Honor to approve.
Okay. Okay, in paragraph 21,
Yes.
we're back to posting again on this site, but everybody's going to get their individual notice.
Correct.
And if it's no cure costs, you're going to put a 0 in there, right?
Correct.
Okay. What are the DCL instructions that are referenced in this paragraph?
Those are the instructions, I believe, to access the case website. Yes, in the motion on paragraph 39, page 31, instructions regarding how to view the list on the case website.
Okay. Okay, in paragraph 28, the last sentence says, if there is no objection, this is to a supplemental designated contract, then the debtors shall obtain an order of the court, including by filing a certification of no objection. Shall should be may. paragraph 29, I view this as substantive, and we're in a procedural order. So why should this paragraph be included in a procedural order?
Well, I believe we are going out with the designated contract list, and I think the debtors would need some certainty with respect to if they don't receive any objections or otherwise notified by the contract counterparty that they don't agree with whatever is being set forth and the information being provided, the debtors should know at that time and should be given certainty with respect to what the cure cost is going to be for those relevant contracts.
I'll deal with what happens if somebody doesn't file an appropriate objection when they don't file the objection. But this is prejudging what's going to happen, and it even envisions a subsequent order of the court. So I think that happens in the future. So I'm not going to approve this. This is not procedural.
Understood. We will strike paragraph 29.
Paragraph 31 has what I think is an unusual provision in it in the middle. It says, unless the court orders otherwise, the sale hearing shall be an evidentiary hearing on matters relating to the sale transactions, and there will be no further bidding at the sale hearing. I don't expect there will be, but why is that in this order?
Again, I think I would go back to the finality and certainty that we're at.
Yeah, I'll deal with that when we get to the order. That suggests that an auction could never be reopened. It suggests all kinds of things, and I'm just not, that's substantive. Throughout the procedures, the lenders have consultation rights unless they become a bidder and exercise their credit bid rights. When do they have to make that decision? When do other parties get to know whether or not the lenders are going to credit bid on particular assets?
I believe it would be the bid deadline.
Okay, so for each sale, the lenders will have to indicate by the bid deadline whether or not they're going to credit bid.
Correct.
And once they do, then for purposes of that sale, they are no longer a consultation party.
Correct.
Okay. Okay, I have not, those are my comments and questions. The extent that I've got bid procedures here that reflect anything that needs to be changed, it needs to be changed in the bid procedures. I see paragraph 38 of the sale order, which says to the extent this bidding procedures order is inconsistent with any prior order or pleading with respect to the motion, this governs. I think that's fine, as I believe that's cabin to this motion and nothing else that I'm doing or have done. So with those clarifications and with revisions made consistent with this discussion, I will approve the sale procedures. Does anyone wish to be heard? Gold.
Good morning.
Good morning.
Good to see you, Your Honor. Ivan Gold of Allen Mackins for Keys Hotel Operator, Inc., which is the Hawks Cay Resort. First, I want to thank the debtor for working with us on a number of informal comments. And I only rise because your colloquy with counsel for the debtors kind of raised an issue that I think deserves a little clarification. And that relates to your concern you expressed regarding how many notices and are we looking at multiple objections. And I appreciate the need for flexibility here. The debtor is not only selling unique assets, we're not selling 2 forklifts and an F-150. And the likelihood of a global going concern sale, and here global meaning global, it's not impossible, but it is the less likely outcome. We're more looking at geographical pods, single locations, et cetera. And that's, I think, the intent of the chart, which confused the heck out of me too, is to create flexibility that we may have several tracks here. And I get all of that. And what we were looking in our comments was for minimums to assure some level of due process in this process. But your concerns you raised regarding the motion, paragraphs 40 and 41, and then the order, paragraph 32, highlighted this question for me. And to the extent I may have missed this in my discussions with the debtor, I apologize, but I think it goes right to Your Honor's question. Is paragraph 32 contemplates an objection to, quote, a sale transaction. That's different from the procedures of a notice of intended assumption and assignment. So for example, and this shouldn't be a surprise to anybody because we've raised it in prior pleadings, is we have concerns that the agreement by which the debtor operates at my client's property may not, as a matter of state law, even be assignable. And our discussions with the debtors, we reserve that issue. And so that's an open understanding that we have. But as I read these procedures and I listen to your question, the question is, do I need to file a separate objection that this isn't assignable, separate and apart from whatever cure and adequate assurance objections I have? And given the nature of the debtor's operations, I may not be the only party with that concern. But again, am I looking at multiple objections? I don't have a problem with the second notice, or do I save that for when we have a buyer for my property, as opposed to this earlier, more metaphysical objection to selling it in the first place? And that,
if I were you, I'd raise it the first opportunity I had.
Well, I already have, but yes, it could be early and often could be the answer to that. But the question is the way these procedures are drafted, it would appear that we are required to file 2 separate objections. Now, the first one doesn't necessarily have to be elaborate because we've already raised it, but it does. You would ask that question. And so I just wanted to approach with a real life example so that you could kind of get clarity before we delve any further into these procedures.
Well, my thought was that people shouldn't be constrained in the objections that they are filing to, you can only file a cure objection, an assumption, an adequate assurance objection. You can file whatever objection you want. And again, this is where I'm going to give some people some leeway because I think these procedures are confusing. Let me hear if the debtors have a response to Mr. Gold's example of how counter-contract parties are supposed to respond to the various notices they're getting.
The point of the cure notice was to notify parties that they have to object to that cure at that time. They can raise sale objections at a later date pursuant to the order. But it was not meant to preclude people from raising multiple objections or how they choose to do so, only providing a deadline with respect to cure costs and the assumption and assignment notice, which I believe is fairly typical. And to the extent the motion is inconsistent with that, I would not want to be the lawyer arguing to you that the motion controls over the order.
Your Honor, I would direct you to the first sentence of 32 of the proposed order attached to the
Paragraph
COC.
32.
Yes, ma'am, at 369. And to me, it's a completely different timeline. It isn't in response to the cure notice. It isn't in response to the notice of potential assumption assignment. It says any and all objections to any sale transaction must be filed no later than a date that is 30 days from the bid procedure's trigger date. Well, how does that intersect with all this other stuff they're doing? I mean, that's not my cure notice.
No, it isn't.
So this is something else.
This is something else.
And how do we reconcile this something else with the cure notice is my fundamental question.
Well, I don't think it's unusual to have the cure notices go out in the beginning of a sale process so that the debtor can understand and the prospective purchasers can understand what the cure obligations are with respect to any particular contract.
But my point is now I'm up to 3. I got a cure notice and a cure response. We all agree at the back end, once we identify a notice of successful bidder, I may have an adequate assurance
You
objection.
might.
Now we've got one in the middle that you can't sell my property. So now I've got 3. I got 3 notices. I got 3 objections.
Is that
And-
different than normal?
3's a lot. 2 is not unusual to your point, but I just want to clarify. I just want to make sure I understand when I walk out of here.
Which one should I eliminate? I mean, that's the question. Which one gets eliminated? There are 3 different separate things. Because of the way this is developed, where you have to file an objection before the auction has taken place, which we can all discuss the merits offline at some conference, but that's how it's developed, right? So that does put in this.
Well, I understand, Your Honor, and it's traditional to have a cure notice prior to the auction, so everybody knows what they're bidding is.
They have to.
Stipulated. I understand the filing of an adequate assurance objection once buyers have digested the cure notice and the other due diligence information. They've decided to bid. The debtor selects them. They tell us, and then we have the right to object or consent to the proposed assignment. So those 2 pillars are normal. It's the third one is what, do I just want to walk out of here understanding and know that I'm on the same page with you, that these procedures contemplate I've got a third pleading to file somewhere in the middle that would raise the saleability of the asset, that's not something I can do after the auction. I can't wait under these procedures, or do I have to do it on this paragraph 32 timeline? And where that 30 days and how that fits in the chart, I don't even know that this will be the second one. It could end up with the 30 days. It could be the third one. I don't know. That's where I'm confused, having heard your colloquy.
Do you have any response?
I agree with Your Honor's initial inclination. I don't think that this aspect of things are particularly different. You have an assumption and assignment deadline, and you file an objection to the assumption and assignment. If you don't agree that the property that is being sold, which Mr. Gold will know what property is being sold, I mean, he only has, his landlord has one lease that it is responsible for. It will be involved. It will know who is bidding. It will know what asset, which is the lease, is being sold. So I don't know about other parties, but Mr. Gold can file an objection to this. He basically has. But I don't think this is particularly different than how normal sale processes run. Setting aside the chart, which I understand, I mean, it is not the model of clarity, but this particular aspect of things is not different. You have an assumption assignment deadline. You have a sale deadline. And then if you don't agree with the successful bidder or the backup bidder, then you can object to the identity of the bidder. That is not strange or unique in any way.
It isn't. I think it's the sliding scale nature of things that makes things more difficult here. I think your notices need to be very clear as to what they're noticing when people go out, so that when they go out, so that people understand their deadlines for objecting. And I will say now, without giving anybody any legal advice, I am not restricting any objection that is filed to only, for example, the cure costs. If you've got any objection with respect to a contract, just put it all in that first objection and you'll be okay in terms of notice as far as timeliness as far as I'm concerned. So I would not wait and try to figure out, I can wait on this objection until this later date, and I wouldn't do that.
Understood. And to be, again, perfectly clear, that chart will not be in the notices that when they go out. That chart will be filled in with exact dates that comport with the time ranges set forth in the chart. That was the entire purpose of the chart, to set forth date ranges for everyone in your honor to see. As long as the dates within the process fall within those date ranges, that is what we were seeking approval of. When we go out with the notices, they will be exact dates. And I understand that leeway will be given. I wouldn't expect anything else. I mean, I understand the unique circumstances of these cases, but we are going to go out with clear notice, and when we deal with whatever objections may be, we will deal with them then. But in terms of assumption and assignment and identity of bidders, I like I said before, I think that is normal, par for the course for bidding procedures. But with that, I will rest.
Mr. Hazeltine.
Good morning, Your Honor. Bill Hazeltine on behalf of Tradewinds Ltd. Tradewinds filed an objection to credit bidding because we assert a first priority lien on the assets in Florida. And we have worked it out with language in the bidding procedures that says that any party can object to credit bidding at the time of the sale objection.
Yes.
And that satisfies our concern.
Thank you.
Thank you, Your Honor.
Anyone else? Okay, then I'll look for that revised form of order.
Thank you, Your Honor.
Your Honor, Sean Greacher again.
Okay, well, I'm sorry, 1 second. With respect to this order as well, I did notice here on notice was going to regulators, who I assumed were regulators over animal welfare. But I think that should be specified in this order as well as to who the regulators are that are going to receive notice.
Understood. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Sean Greacher takes us to matter number 11 on the agenda, which is the collective stay enforcement matters that have been put on for today's hearing. Your Honor, we do have Mr. Wagstaff here in the courtroom. Turn it over to Mr. Nyberg to present the evidentiary side of things, and then we can take it from there.
Thank you.
Thank you.
Mr. Nyberg.
Morning, Your Honor. Michael Nyberg from Young Conaway, on behalf of the debtors. Your Honor, may I approach?
You may.
Just have zip liners on for your clerk as well.
Yes, thank you. Thank you.
Your Honor, the debtors first seek to admit the declaration of Mr. Wagstaff, which was filed at docket number 333. as well as exhibits to it, A through J.
Is that in the exhibit binder, or is that on
Correct, Your
that?
Honor. You'll see in your binder, right behind tab 1 is the declaration, and then behind that are tabs A through J,
Yes.
which align with how they were identified in the declaration.
Okay, thank you. Let me ask, is there any objection to Mr. Wagstaff's declaration coming into evidence? I hear none. Let me ask this. I do not see Mr. Albor in the courtroom, and I know Mr. Moon and Mr. Busenkel have withdrawn. I permitted their withdrawal. Is Mr. Albor going to appear today, or is he represented by anyone in the courtroom? I hear no one. Okay, just for my purposes.
Thank you, Your Honor. I'll just note for the record that exhibits D and F to the declaration were filed under seal, which was approved by an order of the court. They are banking records involving third-party non-debtors, which is why we put them under seal, Your Honor.
D and E?
D and F.
D and F. Okay,
And
thank
then,
you.
Your Honor, before we turn the podium back over to Mr. Greacher, the debtors would offer a brief proffer from Mr. Wagstaff that is intended to cover events that have occurred since his declaration was filed on July 9, as well as, if you recall, Your Honor, the debtors also filed what I'll call a sanctions notice, which was debtors' notice of submission of costs in connection with orders enforcing the automatic stay and imposing sanctions at docket number 355. So if I'll proceed with the proffer, Your Honor.
Yes.
Thank you, Your Honor. With respect to the stay enforcement motion, if called to testify, Mr. Wagstaff would testify about Mr. Albers and Ms. Esteban's actions that have occurred or continue to occur since the filing of his declaration on July 9, 2025. Mr. Wagstaff would testify that Mr. Albert and Ms. Esteban have continued to be uncooperative and have failed to turn over the records to the debtors and have continued their refusal to provide access to the records. He would testify that Ms. Esteban has expressly conditioned the turnover of records on a legal release and a payment of estate funds for alleged severance due to her. He would say Mr. Albert has refused or otherwise failed to return the keys to the debtor's legal department offices at the headquarters. Mr. Wagstaff would testify that Mr. Albert has refused to return the funds transferred to PES in connection with the operation of the debtor's Mexican parks, and has not returned the funds transferred by PES to his personal attorneys at the CDA firm. Mr. Wagstaff would testify that Mr. Albert has not provided the debtors with bank records of PES, or Elysium, which would allow the debtors to trace the flow of estate funds through PES and Elysium. And he would lastly testify that Mr. Albert and Ms. Esteban have not returned the funds transferred to Elysium. And then, Your Honor, in the binder, there's a email at tab 2. Mr. Wagstaff would testify that stay violations that he has identified since his declaration was filed include Mr. Albert's email response dated July 14, 2025, and that's at tab 2, Your Honor. And if, Your Honor, if you'll see, and also as we did with some of the emails that were attached to his declaration, we included at the back end, for Your Honor's benefit, a machine-generated English translation, which Mr. Wagstaff, if you recall, is fluent in Spanish. He would testify that this is an accurate translation, at least as machine-generated. Importantly, Your Honor, I think with reference to tab 2, Mr. Wagstaff would say the important parts of Mr. Albert's email would that Mr. Albert alleges that payments made by PES directly to CDA were made on his behalf and by his order, and that the legal services that he received were personally provided to him by CDA. Mr. Wagstaff would note that the funds paid to the CDA firm by PES do not constitute property of the debtors and were from the cash flows of PES itself. That's what Mr. Albert says. And that Mr. Albert says the deposits from Controlador Dolphin to the PES account were recurrent and began months prior to the petition date. Again, that's all what Mr. Albert says in his email. What Mr. Wagstaff would testify is, based upon these statements in this July 14 email, Mr. Wagstaff and his team at Riveron investigated the flow of funds through the PES bank account. And based upon that investigation, Riveron determined that the average monthly deposits to this PES account between September 2024 and March 2025 was approximately $600,000 a month. And that the monthly credits from the account, or debits, from the account during that same period of time was also roughly $600,000. However, Riveron determined that in the months of April 2025 and May 2025, after the debtors had commenced their proceedings and began trying to take control of the Dolphin Company, PES noted that monthly deposits into the PES account were approximately $3.7 million in April 2025 and approximately $4 million in May 2025. And during those same 2 months, funds flowing out of that account in April 2025 were $3.2 million approximately, and approximately $4.3 million in May 2025. So a dramatic increase in both funds going to that account and out of that account post-petition. And Your Honor, just to help, maybe just a picture's worth 1,000 words, tab 4 is the demonstrative in your binder that reflects the credits and debits to that PES account during those months I just talked about. And Your Honor, lastly, with respect to the sanctions notice, the sanctions notice, Your Honor, is I believe tab 3. Debtors will seek to admit that into evidence. And Your Honor, tab 3 itself also has tabs A through F, which, as reflected on the notice, are the breakdowns of the various professionals that have performed work on behalf of the debtors' estates in terms of enforcing the court's orders, as well as the automatic stay violations and actions taken to combat Mr. Albert's actions.
Okay, tab 3, is there any objection to the admission? I hear none, it's admitted.
Your Honor, lastly, Mr. Wagstaff would testify that he, along with his team at Riveron, reviewed the invoices and or summaries of fees incurred, and that based upon his involvement and understanding of the work performed on behalf of the debtors, that the amounts, the work reflected in the invoices was appropriate in scope and necessary to combat Mr. Albert's actions. I think, Your Honor, with that, unless you have any questions for me from an evidentiary perspective, I'll turn it back over to Mr. Greacher.
Okay, exhibit, or tab 4 is a demonstrative.
Just a demonstrative, Your Honor.
And tab 2 is the email.
2, that's the email we'd seek to admit as an admission by Mr. Albor.
Is there any objection? I hear none, it's admitted.
Thank you, Your Honor.
Thank you, Your Honor. Again, Sean Greacher. Your Honor, once again, we're here before Your Honor seeking enforcement of fundamental protections of the Bankruptcy Code, specifically the automatic stay, and to compel compliance with the court's prior orders, the turnover and the stay enforcement order as a result of the ongoing noncompliance by Mr. Albor and Ms. Esteban. We're also here seeking a determination of liability for the direct cost borne by the state as a result of the willful violations that the court found in connection with the prior orders. Your Honor, as you heard from the testimony and you saw in the pleadings, Mr. Albor continues to obstruct the debtor's access to critical business records and assets, has engaged in conduct that directly undermine the administration of these estates. Mr. Albor has not complied with Your Honor's orders, either in fact or in spirit. In fact, the declaration that Mr. Wagstaff filed provides a laundry list of ongoing violations and efforts to undermine Mr. Strom's and Mr. Wagstaff's proper operation of the business. This introduces unnecessary cost and risk to the operations. It puts into jeopardy the debtor's ongoing ability to run the business and care for the animals. Your Honor, we notified the court of many of these issues back on June 26th. Since since then, Mr. Albour has done little or nothing to bring himself into further compliance with the stay or your order. So I'll point out a few of those issues. Again, interference with assets and financial information. As we noted last month, Mr. Albour attempted to assign assets and rights of the debtors away from the debtors, funnel them through a company called Proyectos Ejecutivos Sostenibles, PES for short. Mr. Albour apparently directed the company's legal counsel, Ms. Esteban, to create a backdated agreement between Controladora Dolphin and PES, whereby Controladora would essentially hand over operations of the Mexican parks and all Mexican park revenues to PES, and PES would, in addition, receive some additional consideration from Controladora Dolphin. That correspondence and that backdated agreement is attached to Mr. Wagstaff's declaration in Exhibit A. Similarly, Mr. Albour directed Dolphin Management to circumvent the debtors' bank accounts with respect to Caribbean affiliate funds and deposit them into an account held by Elysium Properties Investment, which we learned through deposition testimony that is a company Mr. Albour incorporated in Delaware about 10 years ago to be a family-owned entity of which he is the only member. The records show over $263,000 transferred from just two of the company's Caribbean affiliates to Elysium in the month of May. Further, the records we've been able to retrieve also show that these Caribbean bank accounts where Dolphin Company funds were diverted were used to pay Mr. Albour's personal legal counsel in Mexico. So what we know is that Mr. Albour has orchestrated these schemes to divert estate revenues into the non-debtor entities, PES and Elysium, after originally claiming that no estate funds were dissipated on account of non-debtor obligations. I want to be clear about this. Mr. Albour did not tell you the truth under oath when he was asked about estate revenues. If you look at pages 149 to 150 of the transcript of that May 21st hearing, where he was on the stand, Mr. Albour's counsel asked him point blank why the estate's bank balances were so low in the reports that his counsel produced to the debtors. The truthful answer to that question would have been, I have been diverting estate revenues to non-debtor accounts that I control at PES and Elysium. Mr. Albour did not come clean. He provided the debtors with partial, misleading information prior to that hearing and fabricated a story that just the day before, the company had lots of cash, but they had to pay all of that money on account of various estate obligations, and that the debtors' bank accounts were on the verge of being replenished by revenues that were due to come in. His representations in his, quote, certification of compliance, particularly based on Mr. Wagstaff's testimony, should be viewed in that light. They're just simply not credible. And Mr. Albour, as you noted, chose not to come here today to sit under penalty of perjury to try to justify those statements. Mr. Wagstaff's declaration also includes two documents that evidence some of Mr. Albour's misconduct. Again, to justify the story that PS had some rightful claim to those revenues, there was this contract that was fabricated. And second, despite the testimony that no estate funds were used to pay personal obligations, Exhibit C of Mr. Wagstaff's declaration shows the bank records indicating that payments that should have gone to the estate were used to pay personal counsel. They were paid to PES, they were paid to CDA, they were paid to Mr. Caston, and they were paid to a company called Inversiones Garrafon, Garrafon, which we just learned days ago is another entity managed by Mr. Albour. Mr. Wagstaff has demanded all the records and information related to these transfers. Our team continues to uncover further details each day, and it appears that these schemes go even deeper than just the activities that we indicated in the declaration. May have begun even pre-petition. It's critical, Your Honor, that the debtors be provided with access to the full and accurate records and documents, both the physical records, contracts and corporate documents, and the records related to the diversion of assets, particularly the diversion of these funds into the PES and Elysium accounts that were done in an effort to circumvent the impact of the Mexican orders granting Mr. Strong and Mr. Wagstaff access to the bank accounts. And Mr. Albour has simply failed to provide us with access. Going to the issue of the company books and records, Mr. Albour and Ms. Esteban have repeatedly refused to turn over those books and records, despite the multiple orders requiring them to do so. Rather than cooperating with the transition of these documents, Mr. Albour actively has interfered. We provided correspondence from Mr. Albour indicating that he would direct debtor employees with access to information regarding these schemes to provide it. He conditioned that, though, on those parties being released from any liability. After promising to personally accompany the debtor's advisors to the headquarters to complete the process of documenting and retrieving the records, and as well as promising to appear and discuss with Mr. Wagstaff and his team all the information regarding these PES and Elysium transactions, he decided the day before the planned meeting he would not appear. And on top of that, we learned that he removed the Dolphin Company employees who were appointed at the directors of PES, appointing himself alone as the director of PES, thereby further obscuring and making it more difficult to understand the information and understand the nature of the assets that were related to this scheme. Further, he sent his driver to change locks at the building. When he was unsuccessful in accomplishing that, and when the company began the process of accessing documents while accompanied by a notary appointed by Ms. Esteban, Mr. Albor personally disrupted the process of collecting those legal documents, threatened the debtor's staff, and demanded that they turn over their keys to the building under threat of criminal prosecution. And now recall, Mr. Albor testified, again untruthfully, that there weren't any paper records in the Cancun headquarters in the first place. Again, the May 21st hearing transcript, page 162, he says all the paper records were in the parks. It's not true, Your Honor. Mr. Albor has concocted a news story that instead of the debtor's records being readily available and not commingled with any other non-debtor property, which is what he testified to prior to the hearing on the stay enforcement, the records were now apparently held in a portion of the building that he no longer had any control over. He instead advised that he has leased that portion of the building to his personal attorney, Ms. Esteban, who is also acting as general counsel to the company. And therefore, Mr. Albor suggests that he can't do anything more to comply with the court's order. That's Exhibit H to Mr. Wagstaff's declaration. And of course, this is inconsistent with his verified response on April 28th. It's inconsistent with his deposition testimony when he asked who was in physical control of the debtor records located in the headquarters. And it's inconsistent with his testimony in this courtroom. And in fact, if you look at docket number 155, his supplemental response, the statement is, Mr. Albor remains willing to grant Mr. Wagstaff and his team supervised access to any physical records located in his office that cannot be shared electronically. When he testified here, he insisted only that the debtors need to simply agree to a respectful protocol with him. Him alone, not Ms. Esteban, to access all the debtor records in the headquarters buildings. And after the court codified that protocol in the order, Mr. Albor took every single possible step he could to disrupt and interfere with the debtor's operation and management and collection of those documents. And he continues to stand in the way to this day. Your Honor, whether Mr. Albor has put Ms. Esteban up to conspiring with him to continue to stonewall the debtors from accessing these records, or if she's acting on her own accord, Ms. Esteban has similarly not complied with the debtor's demand for cooperation and access.
What notice has Ms. Esteban got of anything?
Well, so she is an employee.
What notice has she got?
She's received electronic mail, and I believe we sent her a physical mail. But I'd have
Has
to.
she been served with the notice of motion? What has she?
Yes, she's been served with.
We have certificates to serve.
Okay. I believe we do have certificates. I'm happy to continue, or if you want.
You can continue. I really have some basic procedural questions about what's in front of me and what I can do. The notice of, at the previous hearing, I said we would go forward with the damages hearing today. As I understand it, that's Exhibit F, the notice of submission of costs is what the debtors filed in response to that. I didn't get any legal authority for what it is that I can order under 362K, which I take it, or maybe I should ask you, what provision of the code do you think I'm ordering sanctions under or damages?
So Your Honor, we think it is under 362K, and we think it's under your prior sanctions order. I think your prior sanctions order indicated that sanctions would be imposed.
Sanctions are different than damages. So talk to me. I have no authority in front of me on 362K or, quite frankly, on sanctions. But, and I've requested it before, okay, is what do you want and what authority is there for me to grant what you want? And so I don't have anything in front of me that tells me how I apply 362K and what the standards are and how I should view the evidence.
So, Your Honor, I would suggest that, and I'll go back to our briefing and our argument in connection with the prior hearing. I believe that we submitted a handful of cases, and I believe, I'll just make sure that I have that right. But I think we spoke about these cases in connection with the follow-up hearing.
Well, the follow-up hearing was for sanctions, and I entered a sanctions order, and I did a $10,000 a day order on sanctions. Right. Now you want damages.
Yes.
Those are different. At least I think they're different. Maybe I'm wrong, but I don't have the briefing in front of me on 362K, if that is the provision that you're relying on.
And Your Honor, I think we did raise this in connection with the hearing. It was the hearing where Your Honor asked us to come back and argue with respect to the evidence. It was the hearing after the evidentiary hearing. We came back, and Your Honor asked us to provide you with a discussion of what the appropriate remedies were. What we had indicated was that there were sort of two paths. One is Section 362K indicates that the sanctions are appropriate to a corporate debtor. We also cited Judge Dorsey's opinion in the N 400 case, where he said that under Section 105, any type of order is whether it's injunctive, compensative, or punitive, as long as it's necessary or appropriate to carry out the provisions of the code, are authorized.
So you're coming to me under 105 and that's it?
Well, no, I think the 362K gives you the right, and I think if you look at the Atlantic Business case indicated, and Judge Goldblatt acknowledged this in the Healthcare Real Estate Partners case, that 362K is applicable to corporate debtors. What I'm saying is that even if 362K weren't applicable, Judge Dorsey, under the N 400 case, has imposed sanctions under
I'm talking
105 as
about
well.
sanctions. There's two things going on in this hearing today. One is you filed another motion to enforce. Okay, that's one thing. Then we're supposed to have a hearing on damages. Okay, damages to me, at least I think that's what my order said. Let me just double check. Yeah, an evidentiary hearing is scheduled for July 23rd at 10 for determination of the damages, if any, Mr. Albor is liable for based on cost to the estate of responding to Mr. Albor's actions.
Yes.
Okay. So that's what was requested. I said that's what I ordered. 362K, it's not apparent to me exactly how one applies that in every situation. It just says that you recover actual damages, including costs and attorney's fees, and in appropriate circumstances may recover punitive damages.
And Your Honor, all we are asking for today, and what all the notice asked for today, is the costs and attorney's fees. That was the notice that was filed.
Okay.
And so, Your Honor, that's all we're asking for today. We believe that there are other types of costs of damages that could be sought, but today, all we're asking for are the costs and attorney's fees, which are reflected in the notice.
So you're not asking anything with respect to the notice of motion and the motion that was filed at docket 332?
Not with respect to further costs and attorney's fees.
What are you requesting on that?
On that one, we do have a form of order. It's attached And the requests are, again, for the parties to provide us with the records related to the debtors and the debtors' estates, the documents related to PES and Elysium, and the return of the funds that were diverted. So if you look at paragraphs 5, 6, and 7 of that form of order, those are the requests from the additional motion.
Okay. Well, I would like some authority. I'd like a written submission discussing the authority under which I can assess the costs and damages and what can be assessed. Because I don't have it in written form, even if you may have thrown some cases at me during argument in a previous hearing. And I want to ensure, and I got, I think, a couple of sentence proffer with respect to how these costs were put together. But for example, I see in the Young-Conaway submission, prepare for and participate in meeting with Young-Conaway Ray first day hearing issues. Well, I don't know that first day hearing issues get charged to Mr. Albor. Okay. I saw some, and maybe they do, but I need some written submission with authority. It looked like some of this was, like some of the submissions were broad. I think Riveron had some as well that seemed very broad to me, where I couldn't discern just from looking at the document that was in fact something done in response to Mr. Albor. And then I think I need authority for why Baker and McKenzie's fees can be assessed as damages. Maybe they can, I don't know, but I have no authority that tells me that I can assess the lender's fees, attorney's fees and costs to Mr. Albor.
Okay, well, so Your Honor, we're happy to put together a written submission, and just for the avoidance of doubt, it sounds like the question is not that, whether or not the costs are, whether or not costs are accessible.
Give me authority. Just give me authority on everything you want. Don't make an assumption that I know how to apply 362K, because I think maybe I've done it once. Okay, and it's not just that apparent to me. The first question you already talked about was, can you even do it in a corporate case? Well, yes, there's authority for that. I understand that, okay? I haven't looked at it, but I understand that. That's an issue. The other issues are, how do I interpret and apply this section? And, for example, can the lender's fees and expenses be charged to Mr. Albor or assessed as damages and costs? Maybe they can. I don't know. I just want the authority on how I apply this section.
Okay. I understand, John. So I think that relates to the fees and costs point, and we'll endeavor to provide additional briefing in connection with that. Unless Your Honor has any other questions on that, I did want to make a couple more statements in connection with.
And I also want in that submission then the service that was done on both Mr. Albor and Ms. Esteban, but in particular Ms. Esteban, who's not appeared before me. That's, I guess, different. That's on the motion, on the costs. I guess you're not asking to charge these costs against her, are you?
No.
Okay. So that's fine. I'm now confusing the two things. On the motion, I want evidence of the service.
Okay. Very well, Your Honor. I guess just a couple of other points, if I could.
Certainly.
And I guess my question is whether Your Honor is prepared to enter an order with respect to the further violations of Mr. Albor.
I'll review the evidence, and I will enter an order that I think that is appropriate.
And again, apologies, Your Honor, if I'm missing something. I thought the evidence you were looking for was with respect to the assessment of the costs.
I will review the evidence that was just presented to me, Mr. Wagstaff's declaration and the submissions. For example, I heard in your argument, though I don't know that it's in the evidence, I heard argument about pre-petition actions. I don't think those could be a violation of the stay. So I am going to consider the evidence that was presented, and I will issue an appropriate order. I don't know if it will be exactly the order that has been submitted, but I will consider the evidence submitted on the motion and the proposed form of order and make a decision on that.
Okay, I understand, Your Honor. If I could, though, a couple of other remarks with respect to some of the additional filings, and one would be the declaration that was filed by Mr. Duenas.
Yes.
So, and again, I'll note first of all, Mr. Duenas is not here.
Well, was that part of the evidence? Was that submitted?
That was, yeah, that was
attached to the declaration?
So Mr. Duenas' declaration was filed. It's at docket number 305, and it's tab D to the agenda item.
Well, that's not evidence. I have an evidentiary record.
Correct. I'd like to make it. This was filed by Mr. Albor's attorney.
Okay, but it's not part of the evidence, is it? I have an evidentiary record. People file stuff all the time. I have an evidentiary record, and I don't know that declaration was submitted in the evidence. That's what I'm asking. Did Mr. Nyberg today submit that declaration into evidence? I don't think he did. I could be wrong. If it could be attachment to Mr. Wagstaff's declaration?
No, it's not. This is Mr. Albor's attorney in Mexico, and so
why are I considering that? I have an evidentiary record.
Okay. If Your Honor is disregarding that declaration in its entirety, then I don't have any problem with that. I just wanted to make it clear that we.
It's not part of the evidentiary record.
Okay. All right. Very good, Your Honor. All right. Well, so I think that we have our marching orders. We'll prepare a further submission with respect to the damages. Your Honor will review that. We'll review the record that's before you today in our further motion, and we will await further word from Your Honor on that.
Very good.
All right. Thank you, Your Honor. I don't believe we have anything else for the court today.
Thank you very much, then. We're adjourned.